Hi, my name is Brittany Partridge, and I'm an attorney at Butler Kahn Law firm. Sometimes a child is severely injured or killed as a result of their parents' own negligence. So, what happens when a parent is driving their car and in that car wreck, causes a car wreck, and in that car wreck, a child is severely injured or killed? Can a child bring a claim against that parent? The answer is generally no, but there are exceptions. So first, in the state of Georgia, no one under the age of 18 is allowed to bring a claim, but a person over the age of 18 can bring a claim on that child's behalf. So that over the 18-year-old holds the child's claim and is basically their representative. So in the examples I'm going to talk about here, we're going to say that a mother is going to bring the claim on behalf of their child. So I want to talk through the second part of that, which is, can a child sue their parent? Georgia has what's called intra-family tort immunity, and that means that the state of Georgia values the harmony between families so much that it bars any lawsuits between children and parents and spouses. There are some exceptions though, but I'm going to go through some examples today and show you how intra-family tort applies. So in our first example, we're going to have a traditional father is married to the mother and a child is injured. Now, in this instance, intra-family tort immunity is going to apply. The father and the mother have a relationship, and the state of Georgia wants to preserve that relationship. So the state of Georgia is not going to allow this mother to bring a claim on behalf of the child against the father. There's also a desire to preserve the relationship between the father and the child. So the state of Georgia is not going to allow the mother to bring a claim on behalf of the child because, again, the child still has a need to keep that relationship, or the state of Georgia believes that there needs to be family harmony between that child and the father. So that's our first example where the traditional intra-family tort immunity will apply. Now, an exception to intra-family tort immunity can be found when there is divorce. So let's say that our father who caused the car wreck is no longer married to the mother, and the child is injured. In this instance, there is no longer a need to preserve the relationship between the mother and the father, but there still is a need to preserve the relationship between the child and the father. So there are two claims to think about here. First, the mother in the state of Georgia can bring a claim against the father for the medical expenses she has incurred on behalf of her child. That is the mother's claim. Now, the mother could also try to bring a claim for the child's personal injury, the pain and suffering the child has had, on the child's behalf, but that claim is not going to be allowed. So the first claim for medical expenses will be allowed because, again, there's no more desire to preserve the relationship between the mother and the father because they're divorced, but the child's own claim of personal injury is not going to be allowed because there is still this relationship that needs to be preserved. An instance where the child's claim can be brought is if death is involved, as well as divorce. So, if the father is no longer married to the mother and the child is injured, and the father unfortunately passes away in the car wreck. So, there's those two claims we talked about, the medical expenses and then the pain and suffering of the child. Now, because there's no need to keep a relationship between divorced and unfortunately deceased ex-husband and ex-wife, and there's no longer need to keep a relationship between a child and their deceased father, both of those claims are going to be allowed, and intra-family tort immunity is not going to bar those claims. Now, another instance that's a little bit different is if a father and mother are divorced and the child passes away. In this instance, the mother is able to bring a wrongful death claim against the father because they're divorced. And there's no need to preserve the relationship between the father and the child because the child has passed away. Similarly, if a father is divorced, is still married to a mother, and the child passes and the father passes, you're going to have a situation where there's no more need to preserve family harmony because there's no more relationships there to preserve. Now, these cases are very fact-specific, and it takes an attorney to keep up on the law that is ever evolving and understanding the facts of each case to know whether or not a claim can be brought when a child is severely injured or killed as a result of their parents' negligence. So we hope that if you ever find yourself in this unfortunate situation that you reach out to attorneys at Butler Kahn to discuss your options. Thank you.